Your Honor, regarding bond, Mr. Williams is the father of 4 children. He works 2 jobs. He understands testing is going to be part of moving forward. The sober link and random testing do not work with the schedule of that is imposed because of the children and the jobs. So he's requesting a tether to test moving forward. We have a very low BAC in this case, but there is a prior from 2019. And Mr. Williams is
what is the alleged BAC?
0.083, Your Honor.
Thank you.
Bond in this case will be set in the amount of a $10,000 personal recognizance bond. I'll order standard conditions, including no assault behavior or possession of any weapons or ammunition. There's to be no use of alcohol, illegal drugs, or any recreational marijuana. I will order that the defendant is to report to community corrections for placement on a scram testing unit. And then I will adjourn this. How much time did you need?
Your Honor, if we could get 3 to 4 weeks, we do have several videos I've been told by my staff. We have not seen those. I have not yet had a chance to review the video evidence.
During this matter to, Joe Hall showing up on this date, that'd be about right. April 1st.
Funny enough, Judge.
26.
Well, Judge, the issue there is I am
what is it? National holiday for you.
Orlando.
Right?
Yeah, exactly, right?
Exactly.
Your Honor, I think the world is fooling me that day.
It's holiday.
Your Honor, I think the world's fooling me that day because I've been lured into going to Disney, and I will be, suffering in my own way, but I'll be out of state, Judge.
When you go, say hi to the mouse.
I sure will, Judge.
Really, not for me, for Ann. I don't understand the mouse.
You know what? I'd rather.
But if you see Donald, him and I are more. We have much more in common.
And Your Honor, on the 8th, I'm in actually Charlotte, Michigan, in person in the morning.
Charlotte, but that's okay.
They tell me, I don't know.
No,
to be honest,
right.
I wish I
think the way you said it is correct.
I wish I never had to learn, Judge. I already regret some things about that.
The 15th.
April 15th.
That works for my calendar, Judge.
April 15th, 2026, 9 a.m. Bond will continue as said.
Thank you, Your Honor.
Thank you.
Good to see you, Judge.
Good to see you. I really do like the mouse. I do. We should get time. Court does call the cases of the people versus Byron Blair.
Morning, Your Honor. Raymond Cook of the People.
Good morning, Mayor. Police Court, Your Honor. Attorney Damian Cass, P number 85852 on behalf of Mr. Brian Blair.
Blair, can you state your name, please? Do you hear?
Yes, Byron Blair.
Byron Blair. Thank you.
Ron Brown appearing on behalf of Mr.
All right, what are we doing?
Your Honor, on my matter, I am asking just for a brief adjournment to potentially the 18th or the 25th. I am seeking some information from a treatment facility that I have yet to receive so I can submit a deviation letter. And also asking is if the current potential offer for the 1-for-1 is still open.
The offer that was previously extended for 1-for-1 will remain open as long as the defendant remains compliant on bond.
I would join in the motion to adjourn.
Turn these matters to April 18th.
April 18th.
2026, 9 a.m. Thank you.
Thank you, Your Honor.
March 18th. I'm sorry. March 18th.
March 18th. Okay. All right. Thank you.
All Joe Hall's fault. Court calls case. People.
Raymond Cook of the People.
Oh, no. Hold on. It's my worst.
Good to see you too, Judge.
Absolute worst nightmare.
Always a pleasure.
No, well, it's kind of a nightmare.
Okay.
It's like I won't call it a nightmare. I'll call it like a really scary dream.
Understandable.
Okay. And that's
I get it.
Go ahead. You guys state your name. The two of you together is just
dynamic duo, right?
okay. that's
I don't know, is that bad or good?
Of all the
Paula
attorneys,
Johnson.
thank you. Of all
Yes,
the
sir.
attorneys you could get.
It is her lucky day. So, Attorney Hugo J. Mack, Your Honor, appearing with Ms. Johnson, dynamic duo.
This is now going to take a turn.
A good turn.
Well, I don't know. I'm just
You
saying,
don't know.
we don't know.
You know, Mr. Cook has come up with a brilliant idea, and my client is fully willing to comply if the court will allow it. So there's a possibility here, if Mr. Cook agrees to enter a deferred sentence on this matter, Judge.
Is she going to plea? Is that?
Yes.
Do I have forms?
No, Your Honor, I'm filling it out right now.
Okay. So everything's not done. You didn't let Mr. Cook know that's what you were doing.
Well, he knew, but he was so busy. They're so
Okay.
they're so overworked in that.
All right. So what I'm going to have to ask you to do, has she signed an advice of rights form? She's
No.
not done anything.
No.
Yeah, dynamic. Just dynamic. Listen, I'm going to pass it. Let you get all the forms filled out, then I'll call you back up.
Appreciate it.
Okay.
Thank you so much,
Thank you.
Judge.
No, that's not my fault, right?
What?
I said, that's not my fault. They didn't give it to me.
No, I know nothing is ever your fault. We've been through this before. Court calls the case People versus, is it Zeke Church?
Morning, Your Honor, Raymond Cook with People.
And Judge, good morning to you and the staff. Vincent Haysha with and on behalf of Zeke Church, who's present through Zoom without objection.
Church, can you state your name, please?
Zeke Church.
Okay. And what are we doing? Are we entering the plea today?
We are.
Let's get my forms here. Forms I have before me indicate that the defendant will be pleading guilty to the charge of disturbing the peace, a 90-day offense. Upon a successful plea to that charge, count one would be dismissed. There is also a sentence agreement of prosecutors deferred. That's a court's full understanding of the agreement.
That's correct, Your Honor.
Ours as well, Judge.
All right, very good. Church, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again for the record, please, sir.
Zeke Church.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes.
I'm trying to get to the court. It won't let me get to.
Well, can Motorola, can you? Thank you. So, sir, just because we had an interruption there, you understand the maximum penalties, is that correct?
Correct. Yes.
And understanding those penalties, do you still wish to plead guilty?
Yes.
And to that charge?
It's a done.
Okay. Whoever, one more time for the person marked Motorola, and then I'm just removing you from the courtroom. Sorry about that, Mr. Church. So, Mr. Church, to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct, sir?
No, I don't think so.
Zeke, this is the form that we went through that you gave me permission
yes.
to sign.
Yes.
Okay, so you caused it to be signed on your behalf, is that correct,
Yes.
sir?
Correct. Yes.
Do you have any questions regarding any of those rights?
No.
All right. Looking at paragraph 5, those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights that are on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes, Your Honor.
On the date of March 29, 2025, at the location of 4095 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, what did you do that makes you think that you're guilty?
May I voir dire, Your Honor?
Yes, you may.
Mr. Church, that location that the judge just mentioned, was that better known as Besting Games in Pittsfield Township? At least to you? Mr. Church, can you hear me?
Yes, sorry. Yes, Besting Games.
okay.
Yes.
Okay. On that date, were you present at Besting Games?
Yes.
Did you engage with two individuals that you did not know?
Yes, I did.
And while you were engaging, that involved some pushing and shoving?
Yes, it did.
And that happened, you'd agree, in front of other people in the general public?
Yes, correct.
And who of course, observed this. Is that fair to say?
Yeah.
I'm satisfied, Your Honor.
All right. Would you agree, sir, that disturbed the peace and repose of the immediate area surrounding where you were?
Yes.
All right. Sir, I do have to advise you that if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Understood.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
None, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
You have.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Well, yes. Defendant is referred to probation for a pre-sentence recommendation and consideration of prosecutor's deferred. Sentencing in this matter will be
April 8th at 9 a.m.
April 8th, 2026, 9 a.m.
That's great, Judge.
Bond with its conditions will continue. Do I have probation? I do. Mr. Church, I'm going to ask you to remain online. We're going to put you into a breakout room with my probation department so we can begin the sentencing process. Okay, sir?
Okay, thank you.
Thank you.
Thanks, Judge.
Thank you. Court calls the case of the people of Chapman.
You're ready to cook for the people?
Ron Brown appearing on behalf of Taylor Chapman, Your Honor.
She here. Oh, there she is. Ma'am, could you state your name, please?
Taylor Chapman.
Thank you.
Your Honor, I'm requesting a brief adjournment in the matter. I wasn't able to talk to her.
Okay. Ma'am, I'll adjourn your matter to March 18th, 2026, 9 a.m., or as your invite indicates. And do you have phone numbers and connection information, or does she need to call the?
Please call our office.
All right, ma'am, if you could call the public defender's office and just make sure they have your correct phone number and email.
Okay.
Do you have that number?
Yes, it's on the letter.
Okay, very good. Okay, thank you, ma'am.
Thank you.
Court calls the case, People versus Carlton Cross.
You're ready to cook for the people?
Ron Brown appearing on behalf of Carlton Cross, Your Honor. Mr. Cross, are you on the call?
Not checked in.
Not checked in.
Oh, this person.
Or is he here?
He might be in Zoom.
What's your name, sir? I can hear you. What's your name?
Sorry about that, sir. Carlton Dion Cross.
Okay.
Your Honor, I'm requesting an adjournment after March 24th. He has a circuit court pretrial that date, and we're trying to resolve the case. He was not accepted into the sobriety.
He was not.
He was not.
April 1st, 2026, 9 a.m.
I'll be in touch, Mr. Cross.
Bond continued. Thank you, Mr. Cross.
Thank you. Thank you, sir, Judge.
Yeah. Cross case, People versus Shamika Kurtendahl.
Morning, Your Honor. Ready to cook for the people?
Ron Brown appearing on behalf of Ms. Kurtendahl. Ms. Kurtendahl, are you on the call?
Yes, hi, good morning.
Good morning.
Your Honor, I'm requesting a brief adjournment.
Ma'am, In the matter, March 18th, 2026, 9 a.m. Bond continued.
We'll be in touch, Ms. Kirkendall. Thank you.
Thank you,
Okay,
ma'am.
thank you.
Court calls the case of People versus Ishmael Davis.
People.
Ron Brown appearing on behalf of Mr. Davis, Your Honor.
What? Hold on a second. Why are you telling the baby to be quiet? No, tell Feaster to be quiet. That baby can talk all it wants. I was only hearing Feaster. Apology accepted. All right. What are we doing in this one?
My last notes in the file indicate I believe he was in treatment, Your Honor. I tried calling him last night and got a hang up.
Okay, he's still in treatment.
I haven't verified that, but that was my last note.
All right, but do we know where he's in treatment?
No.
We don't? You just have a note that he's in treatment?
Yes, Your Honor.
All right, well, if you verify that, then fine, but at this point, I'm going to issue a bench warrant for defendant's failure to appear. Bond is setting him at $5,000. I'll give a 10% privilege on that. That warrant will issue immediately.
We hold at least to the end of the docket.
No.
Okay.
I mean, if you get the information, we'll take care of it. But court calls the case. People versus, is it Comaria Davis?
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Davis. Operating while intoxicated.
Do I have that one?
We don't have the sign or advice.
I gotta have them to my staff, Mr. Brown. Do I have an advice of rights signed by him?
We emailed all this stuff, but we just printed it this morning, the plea form for you. But if you don't have it, if you pass it, we'll have him sign another. Sign it and send it over.
Yeah, an email.
Here, go, please, I'll give you another one.
Court calls the case. People versus Wilmer Hudson.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Wilmer Hudson.
Name, sir?
Wilmer Hudson.
Thank you.
Your Honor, I'm requesting an adjournment. I've talked to Mr. Hudson. We still have some issues we have to resolve as it relates to discovery.
March 18th, 2026, 9 a.m.
Thank you.
Continue.
You then.
Okay.
You're welcome.
Court calls the case. People versus Alicia Kolowick.
Marshall Feaster, Assistant Post Defender on behalf of Ms. Kolowick. Please state your name for the record, ma'am.
Alicia Kolowick.
Got her?
Yeah.
Okay, go ahead.
Thank you, Judge. I believe this is the file. Yes, this is the file that I really want to set for final settlement conference and jury selection, Your Honor. I think this had previously been adjourned because she had a death in the family. That's what the notes indicate. We'd like to set it, please.
Jury final settlement conference. April 10th, 2026, 9 a.m. Jury selection, if necessary, April 13th, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Judge.
Bond continued. Thank you. Court calls case, People versus Shannon Kiesling.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf. I'm requesting an adjournment. I'm trying to get the restitution figure in this case. We have a partial resolution. I just want the restitution.
How much time are you gonna need to get?
How long?
If we can get at least 2 weeks.
At least 2 weeks, or you need more?
More.
I'll take 2, Your Honor. If the court.
April 1st,
Thank you.
9 a.m. Bond continued. Thank Austin Knox.
Morning, Your Honor. People.
For the Judge, Marshall Feaster, Assistant Post Defender on behalf of Mr. Knox. Mr. Knox, please state your name for the record.
Austin Knox.
Thank you, sir.
Thank you, Judge. Mr. Knox had a case similar to this in 1482. I informed Mr. Cook about that this morning. We're going to look into that further and see what kind of resolution we can find. We can have a brief adjournment, please, Judge.
Adjourn this matter to April March 18th, 2026, 9 a.m. Bond continues.
Thank you, Judge.
Thank you.
Tension shifts as a routine exchange suddenly turns personal. The attorney tries to move things along, focused on paperwork, but the judge locks onto something else entirely. A simple detail, the baby isn't here, and now the tone changes. The questions come sharper. You sent the baby away. There's hesitation, a quick attempt to explain, but it doesn't land. The judge repeats it slower this time, more pointed. You sent the baby away. Now the courtroom feels different. The defense stumbles, apologizing, trying to justify it as practical, but the judge isn't buying the logic. There's a pause, then a cutting remark slips in, half humor, half warning. Control is reasserted. The moment ends with authority, but not without making it clear who's really running this courtroom.
Court calls the case, People versus Lipsy.
Morning, Your Honor. Raymond Cook for the people.
Assistant Public Defender on behalf of Mr. Lipsy, who's approaching the podium. State your name for the record.
Lipsy. Thank you.
Thank you,
Take your
Judge.
hands out of your pockets also. Thank you.
I did show Mr. Cook Mr. Lipsy's proof of insurance today. I believe he's going to be dismissed.
That's correct, Your Honor. People will be dismissed.
Really? What'd you do with the baby?
The baby was here too early. They're not scheduled till 12.
So you sent the baby away?
I'm sorry, Judge. Yes. I asked him to come back later, Judge. I didn't want the baby sitting here for 3
You
hours.
sent the baby away.
I sent the baby to go play, to go have fun.
You sent the baby away.
I did. Yes, Judge. Sorry. I did them already.
Case dismissed. Take you.
Okay, sir. Good luck to you.
I sent the baby away.
I'm sorry, Judge.
He just knew that I enjoyed the baby more than him. So he was jealous. So he sent the baby away. Court calls the case, People versus Elizabeth Lman.
Your Honor. Raymond Cook.
Ready again, Judge Portia, Mr. Assistant Public Defender appearing on behalf of, and hoping she's here, Elizabeth Lman.
She's with the baby.
Apparently, Judge, a message from Ms. Lman did not receive any call back. For the record, I will request an adjournment, but I do not know where she is.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give a 10% privilege on that. That warrant will issue immediately.
Thank you very much, Judge.
Calls the case, People versus Paula Johnson.
Morning again, Your Honor. Raymond Cook for the people.
Sharing with Ms. Johnson. Ms. Johnson, you're here. State your name for the record for the judge.
Paula Johnson.
Thank you. Your Honor, I have before me a plea form that indicates that the defendant will be pleading to retail fraud second degree, the 1-year offense, upon her pleading guilty, upon her successful plea to that charge, which is, I think, as charged, right? The defendant agrees to pay restitution in the amount of $1,039.41. And also there's a second sentence recommendation. Prosecutors deferred with the payment of restitution. That's the court's full understanding.
That's correct, Your Honor.
That's correct, Judge.
May I have her sworn?
Yes.
Raise your right hand. Do you solemnly swear and affirm to tell the truth? Do you solemnly swear that the testimony you're about to give the court is the truth, the whole truth, nothing but the truth?
Yes.
State your name for the record.
Paula Johnson.
All right. Ms. Johnson, is this court's understanding you're going to plead guilty to the charge of retail fraud second degree? That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form. Is that correct? Any question regarding any of those rights?
Yes, sir.
Look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
The plea is already in motion, calm on the surface, but the weight of it is building underneath. The defendant admits it plainly, taking items, walking out, no permission. Each answer tightens the frame. Then comes the shift. The judge leans in, laying out consequences, slowly, deliberately. Misconduct now means no way back, no withdrawing the plea, no second chances. A quiet yes follows each warning, but the pressure is unmistakable. And then it lands, the plea is accepted. Just like that, the case moves forward to sentencing. But the moment doesn't fully release, because right after, the defendant speaks again, almost unsure, asking about restitution. The judge pauses, catches it, and for a second the courtroom feels human again, before snapping right back into procedure.
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes.
On the date or between the dates of May 22nd, 2024 and August 4th, 2024, at the location of the Walmart, which I think is 7,000 East Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, what'd you do?
I went in there and I took some things that didn't belong to me.
Okay. And on these various dates, you walked out of the store without paying for them?
Yes, sir.
When you walked in and did this, were these items that were offered for sale?
Yes.
All right, by Walmart? And you didn't have anybody's permission to take that?
No, sir.
Did you? And I think I asked, the store was open to the public at the
Yes,
time,
sir.
right? All right. And the total amount of property that you took, was that in excess of $200?
Yes. I believe. Yes.
I think we can probably get there with that and or the prior, so. All right. Ma'am, if I accept your plea, I need you to understand that if you commit misconduct between the time of my acceptance of your plea and the time of your sentencing, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None for the defense, Your Honor.
All right, and have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
The court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be April 8th, 2026, 9 a.m. Bond will continue.
So
Thank you.
should I pay any restitution today or wait?
You want to pay restitution today?
I could pay some. No.
How much do you have? How much money do you have?
No.
What?
Misspoke.
Okay, he said I'm saying the wrong thing. I'm sorry.
No, I appreciate your honesty, Ms. Johnson. I don't know what Hugo's trying to hide.
We need a little time. We need a little time.
Okay, yes, sir.
Johnson, do me a favor. On your way down the hallway,
Yes, sir.
stop in at probation
Okay,
so we can start the process.
yes, sir.
I'm sure as I was happy to see you, Teresa will be happy to see
As well.
you. Yeah. All right. Take care. Court calls the case, the people versus Trevor Howard.
Ron Brown appearing on behalf of Mr. Howard. Please,
Trevor Howard.
All right, I have before me a plea form that indicates that he's going to be pleading guilty to no contest to the charge of operating while intoxicated, the 93-day offense. Upon his successful plea to that charge, count one would be dismissed. That is the court's full understanding of the agreement.
Correct, Your Honor.
yes, Your Honor.
May I have him sworn?
Raise your right hand. You swear or affirm that the testimony you're about to give to the court is the truth, the whole truth. Sir. Your name? Trevor Howard.
There's no contest plea, Your Honor.
I understand. Sir, This court's understanding that you're pleading no contest to the charge of operating while intoxicated.
Yes, sir.
That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. Could order your vehicle immobilized, could order your vehicle forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yeah.
Two things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes,
Yes?
yes, sir.
All right. Basis for the no contest plea?
A lack of recall. He was injured in the act.
Sir, to that charge, how do you plead?
Guilty.
No contest.
Oh, no contest, sorry.
You want to plead no contest, is that correct?
Yes, sir.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yep.
Any question regarding any of those rights?
No.
Look at paragraph 5. You'll see one on copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Yeah, 15th District Court.
He was
Okay,
sentenced
were
on
you-
Friday. He wasn't at the time.
You were not on probation at the time of this offense?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because well, I won't ask that. The court has been handed and has been provided Michigan Department of State Police report for their case number 983223. Any objection to the court reviewing that report?
None from the people.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you, if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined in Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
And have I complied with the court?
Yes, sir.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
April 8th at 9 a.m.
April 8, 2026, 9 a.m. Bond with its conditions will continue. Thank you.